Are there tax considerations in mergers and acquisitions? In today's business world, the question of tax considerations in mergers and acquisitions is more relevant than ever. Recent market activities have sparked interest among business owners and investors alike. If you are involved in a merger or acquisition, understanding the tax implications is essential. Tax considerations play a significant role in mergers and acquisitions from a business law perspective. The structure of the transaction, whether it is a merger of equals, an asset purchase, or a stock acquisition, affects tax liabilities and potential deductions. For instance, asset purchases and stock acquisitions have different tax consequences. In an asset purchase, the buyer may step up the basis of acquired assets, which can generate future tax deductions. However, this can trigger immediate tax liabilities for the seller. On the other hand, stock acquisitions usually allow sellers to benefit from capital gains treatment but may limit the buyer's ability to adjust asset bases. Another key factor is tax deferral and exclusion provisions. Certain jurisdictions provide mechanisms to defer capital gains taxes in mergers. For example, South Africa's Section 44 of the Income Tax Act allows resident companies to merge tax-free by deferring capital gains under specific conditions. This can be a strategic tool for tax-efficient amalgamations. Qualified small business stock considerations also come into play. For startups and smaller companies, Section 1202 of the United States Tax Code offers a gain exclusion on the sale of qualified small business stock. This can impact how founders and investors approach mergers and acquisitions. There are caps on this exclusion, which can affect deal structure choices. Changes in tax law, such as those introduced by the One Big Beautiful Bill Act, influence compensation deductions and controlled group rules. This can affect tax planning and acquisitions involving publicly held companies and their subsidiaries. Lastly, the choice of entity type, whether it is a C corporation or a pass-through entity, impacts tax treatment in mergers and acquisitions. This includes the ability to utilize certain tax exclusions or deductions and the timing of tax recognition. Overall, tax considerations are integral to mergers and acquisitions strategy and legal guidance. They influence deal structure, valuation, and post-transaction integration. Legal and tax advisors must analyze these factors carefully to optimize outcomes and ensure compliance.